Thank you, Senator Turpin. Before moving to close this hearing, I'm going to take the chair's privilege and ask just one more question that I think is important to raise today. And it's going to be for Professor Lagomsky. In 1996, Congress passed the Illegal Immigration Reform and Immigrant Responsibility Act. With that measure, Congress attempted to create disincentives to come and remain unlawfully in the United States. An individual who remains unlawfully present in the United States for more than 180 days, but less than a year, is barred from admission for 3 years. Those that are unlawfully present for more than a year are barred for 10 years. In the most extreme case, if one re-enters after having been removed after being unlawfully present for more than a year, they're permanently barred. Exceptions to these bars remain very limited. Professor, in your testimony, you advocated the repeal of the 3-year, 10-year, and permanent bars. You said they create a procedural catch-22, whereby someone who otherwise qualifies for legal permanent resident status has no place to apply for it. Can you elaborate on that for a minute?
Yes, and I apologize in advance that this explanation will be a little bit on the nerdy side, but I don't think I can avoid it. When a person has been if a person is currently unlawfully present, then that, of course, alone is already a ground for removal. As you've indicated, these 310 bars apply to people who have been unlawfully present at some point in the past. My own view is that they are inherently disproportionate to the nature of the offense, even in general, given the desperation that drives people to enter or to remain in the U.S. without status. But the particular procedural catch-22 that you referenced is as follows. Suppose you are a person who meets all of the substantive eligibility requirements that Congress has set for becoming an LPR. That is, you fall within one of the family categories, you do not fall within any of the inadmissibility grounds, and you've waited your turn in line, and now your priority date has become current, you're at the front of the line ready to be admitted. But there is a point in your life at which you have been unlawfully present. You can't simply go to the U.S. consulate and get a visa, which is the traditional route for becoming an LPR, because the moment you step outside the country, you will now have departed, and the unlawful presence plus the departure together make you inadmissible for, in almost all cases, 10 years. The visa will be denied on that ground alone. That would be okay if you could instead simply do the paperwork here in the United States through the process known as adjustment of status. But with rare exceptions, you can't do that. I shouldn't say rare. With an exception of only a minority, you can't do that either. For one thing, you are statutorily ineligible for adjustment if you have not been admitted or paroled. So if you entered the country without inspection, that alone would rule you out. Even if you entered the country legally on a non-immigrant visa, but then overstayed and became unlawfully present in that way, okay, you can overcome the admitted or paroled bar, but then you run into another obstacle. Because to be eligible for adjustment, you also have to show that you have been continuously lawfully present, you have maintained continuous lawful status in the United States since your entry, which you would not have done had you overstayed. To be fair, I should acknowledge an important exception, and that is that immediate relatives are exempt from the requirement of lawful continuous status. But unless you are an immediate relative who became undocumented only by reason of having overstayed, as opposed to entering without inspection, then you're not within any of the exceptions. And despite having met all of the substantive eligibility for requirements for admission, you can't apply for it outside the country, and you can't apply for it inside the country. That's why I describe it as a procedural catch-22.
Thank you very much. Enlightening for those who are unfamiliar with that dynamic, and not very for the many, many who have personally or know someone who is caught in that catch-22. Now, before we conclude, I want to move to enter a number of statements into the record, including statements from Asian Americans Advancing Justice, Americas for Prosperity, and the Libre Initiative, America Families United, the Center for Migration Studies of New York, CHIRLA, Forward.us, Improve the Dream, NACS, National Immigration Law Center, and the National Venture Capital Association. Without objection, those statements will be included, and the record for the hearing will close 1 week from today. Now, as this hearing concludes, I do want to thank my fellow subcommittee members and especially our witnesses for joining us. I'm glad to see that we might have taken some steps forward and made progress today. That's why we held this hearing, to try to find pathways for progress and to improve this outdated and overly complex immigration system. I look forward to working with my colleagues on both sides of the aisle to move the America's Children Act and other important legislation forward in Judiciary Committee. And to just sort of capture the spirit of the last couple of hours, we've heard overwhelming evidence that our immigration system is broken. Outdated visa limits are hurting our economy and endangering workers. Enormous backlogs are separating families, sometimes for years, sometimes for decades. Arbitrary cutoffs are forcing children who grew up in this country to leave their families and their only home. So we have a responsibility to fix all of this. Just think about all the lives and stories reflected in the chart here behind me. If you're a U.S. citizen with a sister in Mexico, you're supposed to wait 224 years before she receives her visa. That's the impact of the current backlogs. If your married child is in the Philippines, he and his partner face a wait time of 155 years. If you're an employer trying to hire a Chinese worker with 2 years of training, your employee should expect to wait 44 years before receiving a green card. Indian workers with a bachelor's degree are expected to wait a staggering 90 years. These aren't wait times. They are de facto bans. And it's past time to make our immigration laws reflect reality as well as the current needs of our nation. And when we do so, that reform will benefit everyone. By reuniting immigrant families, we can help communities thrive. By inviting immigrants to join our workforce, we can grow our economy for all. By welcoming immigrants from countries with lower levels of immigration through our diversity visa program, we contribute to the rich cultural fabric of the United States. By recapturing unused visas, we can reduce employment and family-based immigration backlogs and add billions of dollars to our GDP, reunite families, and strengthen our economy at the same time. By making sure any bill coming out of the America Competes USICA conference includes immigration provisions, we can help build our domestic STEM workforce and encourage startup companies to establish roots here. These reforms are especially important at a moment when our workforce is aging and demand for visas is higher than ever. America has a proud history of welcoming immigrants, and now is the moment to recommit ourselves to that task. As Mr. Melman said in his testimony, by doing nothing, the United States is going backwards. And although it's not a topic of this hearing, I want to conclude by taking a step back and acknowledging a few recent events. Right now, the people of Ukraine are enduring a brutal and unprovoked assault by Russian forces. More than 2.5 million people have already been forced to flee their homes, and that number seems to be growing by the day, creating the largest European refugee crisis since World War II. America must be a leader by example and protect Ukrainians who have been driven away from their homes, just as we should be doing for the Afghan evacuees who made it to our soil, as well as Afghan refugees abroad. At the same time, I urge the Biden administration and my colleagues to remember the refugees who are waiting at our border, kept out by the cruel and unnecessary Title 42 policy. The administration made the correct decision to end Title 42 for unaccompanied children. recognizing that there is no public health need to deny the rights of lawful asylum seekers. It's past time to end this draconian policy for all the individuals and families who come here to escape terrible persecution. So, colleagues, again, I ask that we recommit ourselves to reflecting our values as a nation of immigrants. Thank you all for your participation again here today. And with that, today's hearing is adjourned.